where you own a property in joint names and there's a mortgage also in joint names, and one party, after you've separated, doesn't pay his or her share, I'm often asked whether or not the person who is not paying should repay their share on the transfer value if the house has been transferred from one to the other, or on a sale. So in law, the actual answer is, where you are spouses, you each have an obligation, and if you're cohabitants, you each have an obligation to pay your share. However, where you are spouses and you separate, then the Family Law Act 1985 allows us to argue the possibility that if you've used your money to live elsewhere, that the person who's left in the house and who's paying for the house should pay some kind of aliment to the other party. And so I have successfully said in the past and managed in some cases that have been heard before the courts that we should not repay a share of the mortgage where that person has left the house and is paying mortgage or more likely rental elsewhere, and that fairness dictates that they should not be repaying that sum of money, particularly where they're not resident in the property. But as with anything to do with family law, facts and circumstances are important in each and individual case, and I will be able to help you talk about what's likely to happen in your situation.